record. Okay, everybody, welcome, welcome. We have a couple people listening in on through Zoom, and we've got a couple people here in the classroom as well. We're going to go through some things to help everybody understand the real estate exam prep. Today, what we're going through is we're going to be going through some of the, let me just get this little click correctly, on the license law rules of the commission. So what we'll do is I'll ask some questions, and then if we have any questions, we can go through it. But this is going to be some sample questions or sample things that will help you understand, or things that you need to know a little bit better for the state portion of the test. So you need state too, right? Okay. Which type of written policy is every broker required to have? A, commission splits with the agents. B, company policy and procedures manual. C, sexual harassment policy. Or D, office agency policy. It would be D, an office agency policy. Now, it's a good idea to have the other things, but they're testing you to find out what the law says. And the law says every office must have an office agency policy available so that a consumer could take a look at it. So check with your office to find out where it is. Our office, we put it online that they can download it, so it's available, easy. Number 2, what is true regarding an agent's commission? A, they may receive it from their sellers. B, they may never be paid from a former broker. C, referral fees may be period. Oh, I have a typo in here. Referral fees may be period from. Referral fees may be paid from another broker directly to them. Or D, they are paid from their broker. D. It's D. You can only receive compensation from your employing broker. Now, when it talks about here fees being paid from a former broker, if you left one office and went to another, you can receive those commissions still as if you were there. But this one's incorrect because it says may never be paid. Okay?
The tricky ones.
Yes. So the answer is D. They're paid from their broker, their employing broker. Number 3. Who are the only 2 unlicensed parties you may share any part of your commissions with? A, the seller and the listing agent of the transaction. B, the buyer and seller to the transaction. C, your transaction coordinator and office manager. D, the appraiser and loan officer. It would be B. Now, in a transaction, you can share your fee with a party to it. Meaning, for example, the seller. How would you share your commission with the seller? You could reduce it. So you're sharing it back to them. The buyer, you can pay part of your fee to cover some of their closing costs. Okay? If you leave a firm to work for another firm, you must A, print new business cards. B, take your unsold listings with you. C, notify your broker in writing within 10 days. Or D, turn in all property belonging to the broker to your former broker. I've got a few misspellings. I'm going to have to go through and fix this one. Okay, so what's the answer? D. Okay, it's good to print new business cards, yeah, but that's not a requirement. Take your unsold listings with you. You may not. It depends on your broker, because they're technically the brokers. C, notify your broker in writing within 10 days.
Is it 3?
It's 3 days that you need to do so. And D, turn in all property belonging to the broker to your former broker. Yes. So if you have any signs, documents, contracts, all those things need to be turned into your broker. 5, commissions charged to parties by real estate brokers in Idaho are set by A, negotiation between the broker and the party. B, the Idaho Association of Realtors. C, the Better Business Bureau. Or D, the Idaho Real Estate Commission. Would be A. Another word for this, and you'll see on some tests, is a negotiated fee agreement. It just means that you can negotiate your commissions They're not set. Your office has a policy typically for what they'll charge, but everybody can negotiate those commissions. Number 6, which of the following does not require a real estate license in Idaho? A, sell or offer to sell property. B, property management of an office building. C, negotiate or offer to negotiate a real estate deal. Or D, option or offer to option on property.
I think B.
It would be B, property management. Okay, if you're going to sell or offer to sell something, market for a property for another, you're required to have a license. If you're going to negotiate or offer to negotiate a real estate deal, you're going to need to have a license. If you're going to write an option or offer an option on property, you need to have a license. Property management of an office building, right now, property management is not regulated in Idaho. So you can do that without a license. Okay. What is the one required element of all real estate advertising done by a licensee? A, the brokerage company name must be in it. B, the brokerage company name and main office phone number. C, the broker's name. Or D, the MLS number. It is A, the brokerage business name, the company name. Some people, it used to be that you had to have the company name and phone number, but that's not the case. It just needs to have the brokerage company name. You can have your own phone number and everything else on there, perfect. I've seen some people turn in advertising and they didn't even put a phone number down. It's like, how are they going to contact you? So always have somebody look over your advertising. The MLS number is nice because it helps other agents find the property if they're calling up on it, or it could be a reference. And the broker's name, no. After transferring from one to another, the licensee must, A, have a new license printed and signed, and this is transferring from one office to another. B, request all their listings be canceled, and cancel their contracts with their former broker. C, notify their former broker in writing within 3 business days. Or D, immediately have new business cards made. You have to notify your former broker in writing within 3 business days. Right now, the Real Estate Commission is getting ready to change this part in the law because it really doesn't have to be done in writing. It happens when the licensee's license is pulled because the new broker goes online and pulls their license into their company. Immediately, it's emailed to the new broker, this person's been added, and emailed to the past broker, this person's been removed. Right now, the law says notify their former broker in writing within 3 business days. If you wish to help your neighbors sell their property but do not have a real estate license, you may A, place a for sale sign on the property if an attorney writes the offer contract. B, hold open houses on the weekends. C, refer them to a licensee for a referral fee. Or D, help them fix up their home for sale. What can you do without a license? D, you can help them fix up their home for sale if you wanted to.
Preparing their home.
But you can't refer them to a licensee for a referral fee. You cannot be compensated because you don't have a license. You can refer them to a licensee and say, hey, I know so-and-so that could help you, but you can't do it for a fee. Hold open houses on the weekends? You can't because you're promoting or selling or marketing. Come on in, because you're marketing the property. So that would be that part. And then A, place a for sale sign on the property if an attorney writes the offer contract. You can't do that.
You guys realize how lucky you are to have this man here helping you study?
Glad you got it done.
Me too.
Hey, thanks.
Thanks, brother.
Yep.
You're working hard
Hey, good luck, Ryan.
Thanks, man.
And I don't know who you are, but good luck.
Hey, now. And you can't place a for sale sign to try to market it for somebody else. All right. Number 10, how are original transaction files and earnest money deposits handled in a licensed branch office? Okay, the thing here is talking about a licensed branch office, not a regular office. A branch office is one that's somewhere else. It's not where the main one is, and it is registered with the Real Estate Commission as a branch office. Okay? A, they are to be maintained at the main office. B, the designated broker decides where transaction files are maintained. C, the Real Estate Commission will decide on an office-by-office basis. Or D, original files negotiated through the branch are kept at the branch.
I guess D, but I don't know.
It is D. When you have a registered branch office, it's as if it is another office. They'll have a person that's there that can help manage it and be there and be responsible for it, and documents can be kept there because this other person that manages it would be a broker, so to speak. Now, if it didn't say a licensed branch office, it just said in a branch office or another office, like where you are, the documents are still kept with the brokerage at the main location. In our office, what we do is we have everything be electronic, so it makes it easy for people to submit. No matter where they are, they can have access to those files.
So that helps. So Murdoch and Manwaring, for example, is just a branch of Keller Williams, and so all files go back to Keller Williams with you.
So to speak.
Okay.
Yeah.
That,
Okay. A designated broker wishes to open a licensed branch office in a neighboring community. Who may be the branch manager of that new office? A, any licensee of the branch. B, any licensee with at least 2 years real estate experience. C, the designated broker of the main office. D, an associate broker licensed in that branch office.
is it just A? Wow.
It's D, an associate broker. So you must have a broker's license, and you can be assigned to work in that branch office. Ultimately, the designated broker in the main office oversees everything, but they have an associate broker in that office because the files are going to be kept there and maintained there. Now, an associate broker has the same license as the designated broker. They're just not responsible for everything. Okay? I'm trying to explain it in a simple way. The designated broker of ABC Realty, Inc. quits the business. What must the firm do? A, close up shop until a new broker is located. B, find a new broker within 3 business days. C, find a new broker within 10 business days. Or D, merge with another firm that has a designated broker. So this one's going to test you on the number of days.
So we got C then.
It would be C. You have 10 business days to find or designate a new broker.
And if you don't, then
The office gets shut down.
okay.
So could the agents do anything without the broker?
No, they can't, Ryan. If there isn't an assigned broker that's responsible for them, they cannot. But the Real Estate Commission gives them the 10 days for the firm to find another person to do so. So if they do within those 10 days, great. If not, then the office is actually shut down. When that happens, a lot of times agents will leave one office when their broker leaves. Because they want to keep going, get everything happening, but that's an ideal time when sometimes people will leave an office when a broker leaves. Number 13, the designated broker of a sole proprietor firm quits the business and the office closes. Who is in charge of the money still in the trust account? A, the former designated broker. B, an associate broker of the firm. C, the Real Estate Commission. Or D, no one since the firm ceases to exist.
B.
No,
Still A.
it's A, the former designated broker. So if the broker quits until there's a new person assigned or receives the responsibility for the trust account, and in this particular case it says the office closes, the last broker is the one that's responsible. Okay, so the former designated broker. May a broker pay an inactive licensee a referral fee or commission? A, never. A fee can be paid to an active licensee only. B, with written permission in advance from the Real Estate Commission. C, if the transaction or referral was made while they were licensed. Or D, only if the licensee has a referral agent status at the Real Estate Commission. Think about it.
That one's wording was confusing.
It's going to be C. If I have my real estate license and I conduct and do the work, and then I turn it onto inactive status, and this transaction takes 6 months to close, I can still receive that fee, but I can't be working on it. I cannot be answering the questions or doing any real estate for those 6 months. But here it said a referral fee. So if I sent a referral to you and I leave the business and it finally closes, you can pay me via my broker. You pay the brokerage firm, the broker can still pay the fee to the agent. Okay?
I get that.
An active licensee sends a referral to an agent across the state. May the referring agent receive the referral fee directly from the title company closing the sale? A, no. Title companies may not ever distribute referral fees. B, no. All referral fees must be paid through licensee's brokerage firm. C, yes, if the written referral agreement stipulates. D, yes, with written instructions from the parties to the transaction. All referral fees must be paid through the licensee's brokerage firm. Now, the broker, now here's the tough part, and I don't want you to get this confused. A broker can instruct the title company to cut checks out at closing. That way it can be divided up, but it must be going through the broker. So this right here says no, all referral fees must be paid through the licensee's brokerage firm. So it is going through the broker, and the broker must make that assignment to say, yes, you can pay this, or no, you can't. Okay, so that's how that goes. A buyer hands an earnest money deposit to their agent when they sign the offer. When must the agent turn that deposit into their broker? A, when the offer is ratified by all parties. B, within 24 hours of the licensee receiving the funds. C, immediately upon receiving the funds. D, a licensee may never handle client funds. So as soon as you receive it, somebody comes in and they hand it to you. Okay, it would be C. Now, when the offer is ratified by all parties, you could have it in the contract that says the earnest money is to be deposited upon acceptance. But it doesn't say that here. It's just saying they give it to you already. So whenever you receive something, that's entrusted. You must account for it. So that's why it says immediately upon receiving the funds. You may not deposit it, but you must turn it into your broker. Now, within 24 hours of the licensee receiving the funds, everybody usually thinks, oh, the next business day, you've got stuff like that. But you're supposed to account for it immediately. Now, the brokerage firm, if they're to deposit it, has 1 business day to make the deposit. So that's why it sounds very familiar. But you must account for it immediately.
So I do want to touch on that because I did get confused on that. So the licensee turns it in immediately, but the broker has up to 24 hours or next business day. Okay. That's no.
Because if I get it late in the evening, I may not be able to make it the deposit. So I have the next day to have it be deposited. But we must account for all entrusted funds or belongings immediately. The Real Estate Commission wants us to write up a ledger card that says received $500, check number such and such. And then we would post on there deposited or delivered to the title company or something along those lines. So we're accounting for it. When must the money be deposited into the broker's trust account? A, immediately. B, upon receipt. C, within 24 hours of broker's receipt or otherwise specified by the parties. D, on or before the end of the next banking day or otherwise specified by the parties. Okay, now this is kind of, earlier I said 24 hours, but it's actually D. It's the next banking day. So I misspoke, but it's within 24 hours. Here it doesn't say business day, so that's why C is not correct. Okay, because it would be the next business day. And D says the next banking day. Okay? You good? Glad you made it.
I hurried.
I was thinking you might hook up on the phone. We got a couple other people connected on the phone. Which is not a proper disbursement of the deposit out of the trust account. So which is not proper? A, when the broker receives verification the transaction is closed. B, upon written direction of the parties to the sale. C, to pay the agent a draw on their commission. D, to the title company to accommodate the closing. Now, read it up again, number 18 at the top, which is not a proper disbursement. Which is not. So when the broker receives verification the transaction is closed, that's normal. So you could do that. Upon written directions by the parties or of the parties to the sale, if you're instructed to do something, you can do that. D, to the title company to accommodate the closing. It's possible if you could do that. C says to pay the agent a draw on their commission. So that would be the one that is not right. You don't pay the agent a draw.
I don't understand what a draw is.
Okay, if I'm trying to get money ahead of time, I can give them or prepay them.
Oh, okay.
So they're drawing or taking it in advance. Okay,
And so you're never allowed to pay them before something closes.
out of the trust account, no. A broker opens a sales kiosk at the local mall. Is it a licensed branch office? A, only if the broker fills out the proper real estate commission application. B, if the mall office allows 24 access by the broker. C, a kiosk may not be a licensed branch office. D, if manned by licensees during mall hours. This one you may not know. If you had to guess, which one would you guess?
I'm going to guess C.
That's a good guess.
I'd say C.
That is a good guess. A kiosk is not a place that you keep things. Because remember, a licensed branch office is where you'll have an associate broker be able to be there. Well, they could. Second thing is all the files would stay there. It's kind of tough with a kiosk. A kiosk many times are those little carts that can move around. You know, some of them are more permanent, but so no. And that is the end of that section. Okay? So you needed state. So that's kind of what the stuff we're going through was this part on it. And you need state and state. Ryan, you needed state part, and is that right?
I needed both. I missed
Both?
one
Okay.
question on the state and three.
I'm going to go through a few things really quick on the national as well. That'll help everybody out. So I'm going to do that part. So let me just click on here and get to the right screen. One of the things that a lot of people miss on here, I'm going to do state because you just need state, right?
Mm-hmm.
Okay, I'm going to do another state thing. This is the brokerage representation part. And let's see if I can click the right button. Okay, brokerage representation. This is agency. Agency is something that I think a lot of us can get confused on. So these next questions will really help us out. If you understand it, it will be good. If it's confusing, we'll talk about it, try to make sure that we understand. A listing agreement with the seller in Idaho must have all the prescribed information except A, conspicuous beginning and ending date, that's the term. B, any fees payable by the seller and when. C, the commission split the listing will offer a cooperating broker. D, signatures of all the owners. Now, on the current listing, these things can be on there, but it's the one that we're going to mark is not required. It's C, the commission split between the listing, what they're going to offer the other side. with the Idaho Realtor forms, they have that on there, so that's why some people get confused with this question. But the Real Estate Commission does not deal with that. So it doesn't have to have that. The law states the other things need to be on there. Okay? So that's what you're going to have to remember. The commission split between the listing, what they're going to offer the other side. So if my company policy is to accept a 3%, let's say a 6% brokerage fee, and I'm going to share 3% or half of that with the other side, the listing agreement doesn't have to say that.
Probably because it has nothing to do with the closing anyway. That's afterwards.
Because it'll be divided afterwards is one thing, yep. Okay. Broker A refers a buyer to broker B across the state. What duties does broker A owe to the buyer during the sale? A, none. B, referral agent duties. C, client duties. D, independent inspection of the property. So when you refer somebody from one agent to the other, remember we were talking about that referral fee just a minute ago, being able to receive fees? Does that agent that referred them do anything? Remember, because if they refer them, they're not going to participate at all. They're done. So are there anything that they're supposed to do? So the answer is
None.
none. When you transfer it to somebody else, you're giving it to them to do. You're referring this person to them. So you don't have to do any referral agent duties, because I don't know what that is. It sounds pretty cool. Client duties, they're not signed with a representation agreement. Independent inspection of the property, well, it would be nice to have that, but you're not going to be the one to inspect the property. All of your listings belong to whom? You, your broker, the seller, whatever your contract with your broker stipulates. It's going to be with your broker. In Idaho, all contracts, whether it's a listing or it's a buyer representation, belong to the broker. In an office that allows for limited dual agency with assigned agents, how would the broker herself work with a buyer client to buy an in-house listing of one of her agents? Now keep in mind, if it's going to be assigned agency, you have to have 3 different people, the broker and 2 different agents. It has to have 3 different people. Now here it says in an office that allows for it, how would the broker, the one person in the middle, work with a buyer client to buy an in-house listing? Are there 3 different people? No, there's only 2. The broker is one of the 2 agents as well. So can you have assigned agency if there's only 2 people instead of 3? No, you can't. It takes 3 different people. So A, she would be one of the assigned agents. That's what a lot of people are going to pick. But we don't have 3 people, so no. B, she could not represent a buyer client in this scenario. C, she must leave the buyer a customer and then write the offer. Or D, she would represent the buyer with limited dual without assigned agents. It would be D. Because on here it says, how would the broker herself work with the buyer? It didn't say to turn him off or send him somewhere else. Because like B says she could not. Well, she can, but she has to change the way that it is. It just said up top, an office allows for it. So you might be thinking, oh, there's no way she can do it because of that. It can't be assigned. It didn't say that. It says, how would she? So she would represent the buyer with limited dual agency without assigned agents. Everybody make sense on that one?
That one was tricky, but I get it.
You get it? Okay. In a sale, the seller is a client of firm A, and the buyer is a client of firm B. What is true regarding agency law? So we have 2 different agencies, and they're both being represented by those different agencies. So A, it is single agency. B, it is limited dual without assigned agency. C, it is limited dual with assigned agency. Or D, it is non-agency. What?
C.
No. Because it's not limited. Limited would only be when it's in the same firm.
Just single agency, right?
So it's going to be A.
I said single agency.
Oh, I thought you
should have
said C.
the letter.
Okay. It
I
is
said
single.
Single agency, which just said A.
Yeah.
Sorry.
So single. because each office is representing their party 100%. The only time it could be limited dual, whether with or without assigned agency, is if it's in the same firm. Okay?
Real quick, non-agency just means you don't have representation. Right?
Yep.
Okay.
It means you're not representing them. You're still assisting them.
So
You
they're
can still be
customer.
compensated. They're a customer.
Yeah.
They're not a client. May the broker work directly with the buyer or seller clients in a transaction if the other client is being handled by another agent of the firm in an assigned agent scenario? A, sure, if they disclose the property. B, only if the broker represents the seller. C, no, the broker must remain the dual agent. D, with written consent of the parties to the sale. I think I've got a typo in here. It's supposed to be that. May the broker work directly with the buyer or seller's clients or seller clients in a transaction if the other client is being handled by another agent of the firm in an assigned agent scenario. Sure, if they disclose, it should say it properly. I had somebody else help me type some of the stuff in so I get it done. So I've got a few little problems here. So 7, which is true of limited dual agency with assigned agents? A, only very large companies may adopt this policy. B, each agent may advocate fully for their client in the sale. C, only companies with agents who can't find their own clients may use it. D, it is not a form of limited dual agency.
B, right?
B, it doesn't matter the size of your office. You can have a very small office. It's more difficult in a smaller office because of confidentiality. In a smaller office, you might be talking about something and somebody else hears it. So that's a disadvantage, but it still can happen. So the key thing here, what is true of limited dual agency with assigned agents, each agent is working 100% negotiating for their side, whether it's the buyer or the seller. It's the broker, he or she would be the limited dual, the one that's limited on what they can or can't do or say. If a builder also has an active Idaho real estate license, what must they do when they sell their homes? A, disclose their license status on any purchase and sell agreement. B, signs an agency representation agreement with their firm. C, gives themselves the Blue Agency Disclosure Brochure. D, pay their firm a real estate commission for each closed sale.
Isn't it A?
It's going to be A. The license law requires that if you hold an active real estate license, you must disclose it to all prospective purchasers at the time of closing or prior to the time of closing. So on the forms that the Idaho Realtors put out, there's a checkbox on there that says seller or buyer currently holds an active Idaho real estate license. By checking that box, it discloses to all parties involved that that's an active licensee.
So I have a question. I think so. It's at time of closing, not
Prior to.
Prior to time of closing.
It's when you write up the offer.
Okay, so
That'd be the latest time. So when they fill out the form.
offer, you have to tell them at that point.
Normally on a listing agreement or in the MLS, people will disclose it there, so it can be seen on the contract or be added to if they wanted to.
If you're buying a home, you have to tell the seller you are an agent too, right?
Right, and they also have the same box to be marked, and that can be sufficient to disclose it.
And again, prior to. So when are you writing?
So when you're writing up the offer, that's considered prior to acceptance. So at that point in time, you're disclosing it. The term used to describe the special relationship of trust and confidence between agent and principal is A, agency, B, client, C, non-agency, or D, fiduciary.
Fiduciary.
It's fiduciary. The term used, okay, agency, well, it's a fiduciary relationship. Agency can be the relationship.
Confident, you still have to.
Well, fiduciary has kind of like a
Has more
like a
definition.
monetary. Yeah.
So look that one up to read for that one. When does a party become a client of the brokerage firm in Idaho? When? A, when they receive the agency blue brochure. B, when they sign an offer to purchase. C, when the agent checks the appropriate box in the agency confirmation section. Or D, when they sign an agency representation agreement. It would be D. Now, when they receive the agency brochure, that's just talking about the options that they have. That doesn't create an agency relationship. In fact, it says in there, receiving this document does not count as that. B, when they sign an offer to purchase, no, by signing the contract, they're not signing the purchase and sell agreement. That's not doing that either. However, C, when the agent checks the appropriate box in the agency confirmation section of the offer, it's disclosing the relationship to everybody. But that's not what it's asking. It says, when does a party become a client? The only time it is when they've signed a written agency representation agreement, whether for a buyer rep, or a seller, a listing agreement. Which is true of the statutory duties licensees owe to customers and clients. A, they are mandatory and cannot be waived. B, they are optional at the direction of the parties. C, they do not apply in the case of limited dual agency. Or D, the designated broker of the firm determines which applies in each case. It would be A. The law says that they're mandatory and cannot be waived. You cannot give up certain things. They're required for customers and clients. You cannot lie to them. You can't deceive them. You're supposed to still disclose all adverse material facts. Okay? Information obtained about a client of your firm must be held in confidence. A, through the end of that transaction. B, from that time forward, even after the end of the relationship. C, until the agency representation agreement has expired. Or D, only information regarding your clients is confidential.
D?
No.
So it's got to be
B. From that time forward, even after the end of the relationship. Once you receive certain stuff that's confidential, it's always considered confidential.
I've heard if it becomes knowledge.
Say that again, Ryan.
If it becomes public knowledge.
Well, if it became public knowledge, then that would be different. So yeah, you'd be okay with that. But until that point in time, you need to keep everything confidential. A listing agency is an agent for the A, buyer, B, seller, C, both buyer and seller, D, non-agent. B, listing. You're helping market the property, so you're working with the seller. Idaho law requires an agency representation agreement to be signed no later than when? A, receipt of agency disclosure brochure, so when you give them the blue brochure. B, before signing an offer to purchase. C, after signing an offer to purchase. Or D, during escrow but before closing the sale.
I'm guessing B, but I don't know this.
Okay, we were talking about this earlier. It is B. Remember, to confirm it is on the purchase and sell agreement, but you must create that relationship before. So if you're going to represent the buyer, you must have a buyer representation agreement signed before the offer. Same thing with the listing. You must have a listing agreement signed before, or a compensation, but if you're going to represent them, it must be before the offer. Okay? You good? Mm-hmm. When must the Commission Agency Brochure be presented? That's the Commission Agency Brochure. A, at the first meeting with the buyer or seller. B, at the first substantial business contact. C, no later than when they sign an offer. D, no later than when they close escrow on a sale. B, the first substantial business contact. And it says contract instead of contact. I have some misspellings to correct, but we're getting through this. How many people must be licensed in a firm to have an office policy that allows for limited dual agency with assigned agency? Remember, I just went through how many people it must have?
No requirement.
No, how many people?
Oh, 3.
3. So the answer is 3. Now, why is it 3?
Because you have to have 3 in order to.
Yeah, you have to have 3 different people. The broker and 2 different agents that would be assigned. One to work with the buyer, one with the seller. What is the status of the final sales price of a property? A, it is not confidential. B, it is confidential. C, it must be disclosed. D, it can only be disclosed with client permission. This one you may not know.
It's not confidential.
Say that again, Ryan.
It's not confidential.
You are correct. The state law says it's not confidential. We had a problem because many people are saying, oh, it's confidential. I don't want everybody to know what I sold it for or what I bought it for. So they started holding out the information from the multiple listing service. And the multiple listing service started to not have any sold data to help with the appraisals. Because appraisers use the sold data and can say, here's what the other properties have sold for. So the Idaho legislature went in and actually codified it by putting it into law that says the sales price of property is not considered confidential or information. Now, this is confusing because Idaho is a non-disclosure state, meaning we do not disclose the sales price to everybody in the world. However, you found the property through the multiple listing service, so it will be provided and entered back into the multiple listing service. That's one of the requirements to be in there. But Zillow, for example, does not get all the sold data because we're a non-disclosure state. However, people can disclose it and share it if they wanted to, but most of the time they don't. When we work with a client or a customer who has signed a compensation agreement, we have a blank to be available to present all offers and counter offers. A, an obligation. B, a suggestion. C, a duty. D, a requirement. Now this is taken straight from the law, the actual words. It's going to be C, a duty. So we have the duty to be available to present all offers and counter offers. There are some real estate offices out there that are limited services, which is fine. However, they still must be able to accept, so receive, and to present the offers and counter offers. Which circumstance is not covered by the Idaho Psychologically Impacted Property law? A, a sex offender lives next door. B, a prior occupant was murdered in the home. C, the home was a clandestine drug laboratory. D, the prior resident had AIDS. So it says which one is not covered by it. So a drug laboratory is not covered by that. An Idaho real estate company has entered into an agency agreement with 2 parties, a buyer and a seller. The buyer is interested in making an offer on the seller's property. Can this occur? A, no, because the real estate company would then be a dual agent. B, yes, as long as written agency agreements have been entered into with both parties. C, yes, if the seller has agreed to pay the commission. D, yes, if the buyer and seller both give their written consent to limited disclosed dual agency. D. It's possible to have it done, but unless you have agreement or both parties agree to do so, you can't do it. So most of the contracts that you have a choice. They can choose assigned agency, a limited dual agency, single agency is one, or assigned or limited dual agency. They have to choose one or the other. If they choose single agency, for example, with a seller, that means anyone that same brokerage firm has as clients for buyers cannot look at that property. If it's a buyer that chooses single agency, it means that they cannot look at any of those firms' listings because they would be potentially limited dual. What is true regarding a psychological impact of an Idaho property? A, it must always be disclosed. B, the agent must disclose only if they are aware. C, there is not a requirement to disclose. D, it must be disclosed only if the buyer asks.
D.
No, it's C. Psychological impact property. People die in homes. Okay, so there's death. If someone's murdered in the home, normally that's considered public knowledge. People had heard about it, was on the news and other things. But there's not a requirement to disclose. However, it doesn't hurt to disclose, so you're not required to, but you still could. We had a property here just recently that there was a murder or something or a suicide in the home, and the people found out about it a couple days before closing because they're not required to disclose it, something like that. So they wanted to get out of the transaction, and they did. The sellers let them out.
But would it be in good faith to disclose that?
I would say it would be good because I don't think you can over disclose something. So, oh, by the way, oh yeah, we knew about that. Or, oh, by the way, this. Oh, really? That way they're aware of it. A seller representation agreement has expired, and the seller signs a seller representation agreement with a different brokerage firm. The original listing agent now has a buyer interested in the seller's property. The original listing agent, A, is a dual agent. B, cannot disclose to the buyer confidential information of the seller obtained while it was listed with him or her. C, cannot disclose information about the physical condition of the property to the buyer. Or D, cannot represent the buyer.
B.
Yep, it is B. Okay, remember, once you have confidential information, you cannot disclose that. Now, on the purchase and sell agreement, under the agency confirmation part, you're not going to say that this person also represents the seller. You're not going to say limited dual or something like that. No. If they're with different firms, they can represent the different parties. However, you cannot disclose confidential information. A buyer contacts a real estate office and indicates an interest in purchasing a home in the area. Without entering into a buyer representation agreement, a salesperson from the real estate office must first, A, provide the buyer with information on properties for sale in the area, B, give the buyer information on mortgage interest rates and terms, C, conduct an independent inspection of the property for the benefit of the buyer and then independently verify the accuracy of any statements made by the seller, D, explain to the buyer the disclosures and duties owed to a customer or client and limited disclosed dual agency as explained in the agency disclosure brochure.
D.
That's a long one. It's D. The agency disclosure brochure, when you give that to a buyer, you're supposed to explain it, give them the options, talk about customers and clients. All these things in here that they're talking about are in that brochure.
So also in the blue brochure is talking about limited dual agency and those sorts of things as well.
Yep, because it'll say that you could be represented either 100% in a transaction with single agency. However, with limited dual agency, it can still happen. You can advocate for more than one party, have different people working on their behalf. So if you have that discussion early on, like you're supposed to, it'll make a little bit more sense. But the people will still ask some questions because it's not always understood. A buyer prospect is interested in seeing a house listed with the real estate company, but does not wish to enter into a buyer representation agreement. A salesperson from the real estate company can show the buyer an in-house listing if the salesperson A, obtains the seller's permission, B, verbally agrees to buyer agency with the buyer, C, provides the buyer with the agency disclosure brochure that explains agency law in Idaho, D, provides the buyer with a limited dual agency consent form. So a buyer prospect is interested in seeing a house listed with the real estate company.
Let's see.
Okay, it would be C. You just need to provide the buyer with the agency disclosure brochure that explains agency laws in Idaho. A buyer representation form in Idaho, A, must be in writing to be enforceable, B, must be on a specific form, C, is not approved under the license law, or D, is illegal.
A.
A, must be in writing to be enforceable. You cannot just assume that this person is your agent. I have people that always say, well, my buyer, my seller. Okay, well, do you represent them or not? Because it changes the way that sometimes you answer a question. Because if you're representing somebody, you're held to a higher standard. All of the following provisions are included in Idaho real estate license law and rules regarding seller representation agreements, except that A, all fees and commissions must be stated in the seller representation agreement. B, the seller representation agreement must be accompanied by a qualified expert's report of the property's condition. This says except. C, the seller representation agreement must be signed and dated by the owner of the real estate of the owner's legal appointed, or should say or the owner's legal appointed and duly qualified representative. D, the seller must receive a true copy of the representation agreement after signing it. So which is true? It says all of them are true except for which one? In there, do we talk about the fees and commissions to be paid? Yes. D, the seller must receive a copy of the representation agreement? Yes. C, the seller representation agreement must be signed and dated by the owner or the owner's legal appointed and duly qualified representative? Yes. B, the seller representation agreement must be accompanied by a qualified expert's report of the property's condition. To get a listing, do you have to have a qualified report from somebody else? No. So the answer would be B, because it would be except. You don't have to have that. So how are you guys going to figure that one out?
By deduction.
Okay, so go through, if you have a test question. Normally on the state and national exams, they will not ask except or choose which one is not. Normally they don't do that. It's not a good way to write test questions.
Oh man, I feel like that's all I was running into on the state exam.
Really?
Yeah, they were really they were specific.
They'll be specific asking for something, but it shouldn't say all of them are true except.
I felt that the
Okay.
test was meant to trick me.
Okay.
But,
I found the wording in the test. That's what's tricky.
right. Yeah.
Because they would just kind of shift some things around on you.
Yeah, and that's why I'm trying to go through these questions and try to explain it a little bit, because sometimes we look at one or we read the top and it says, oh, okay, this. Like that one that says our office has limited dual agency with assigned agents. Then it talks about how can we do this? Well, in your mind, you're thinking limited dual assigned agents. Well, they can't do it. That's not what it asked.
So perhaps read the question a second.
Yes.
Third time.
That's what I found, is go through it again to find out what they're really asking. The three types of agency relationships recognized in Idaho are A, seller's representation, buyer's representation, and undisclosed dual representation. B, subagency, disclosed dual, and seller's representation. Or C, seller representation, buyer representation, and limited disclosed dual agency. Or D, seller representation, buyer representation, and full fiduciary. Go through those words and just think of the words. Which ones are actually in the agency law and which are not? Earlier we talked about agent and fiduciary responsibilities. Seller representation, buyer representation, and limited disclosed dual agency are permitted.
What is subagency?
Subagency, it used to be that when I got a listing, all the other agencies, different offices, were sub-agents because they were working on behalf of the seller as well. That's why they used to say buyer beware, because no one ever represented a buyer. They're always working on behalf of the seller. So sub-agency meant that you can be in another office, still be an agent for me in my office.
Working to bring a client
Yes.
to me. But that's no longer recognized. Is that what I'm hearing?
It's no longer, well, it's still in the laws that you can do it, But Idaho, we're not offering that to anybody because of the liability. Why would I want you, if you're at XYZ Realty, to be out there showing properties, doing all this stuff? I don't even know you. So why would I give sub-agency to you? I could if I wanted to, but why would I do it in today's world? So that's why it's still available. It can be talked about, all that other stuff. Some states still have it, but we don't use it.
But it's not recognized by Idaho either in that same regard.
It's not an agency relationship.
Okay. Oh, I see.
For this question. It still is a way of being able to do business, but it's not an agency relationship recognized right now, right? In a dual agency situation, a broker may collect a commission from both the seller and the buyer if A, the broker holds a state license, B, the buyer and seller are related by blood or marriage, C, both parties give their informed consent to the dual compensation, D, if both parties are represented by attorneys. No. Okay, a broker holds a state license. They already do, right? Whether it's dual agency or anything. The buyer and seller are related by blood or marriage. What does that matter? Both parties are represented by attorneys. No. So both parties, if they give their informed consent to the compensation. So in Idaho, it's written down that we must have it be in writing. There are some people that have a buyer, what's it called? A transaction fee or something along those lines that they're charging. And they're also receiving compensation from the seller. So many times they'll put on that checkbox page, they'll put buyer transaction fee, and they'll put on there paid for by the buyer. That's disclosing it. If you don't have it disclosed there in the check boxes, it would need to be with another form that the Idaho Realtors has put out, or even just a simple statement that says that.
So am I hearing that the seller has to be aware that the broker is charging the buyer?
Mm-hmm.
So the seller needs to be aware. Okay,
because it's right now we already know that the seller's willing to pay a brokerage fee. But sometimes the buyers are going to say, well, I'll pay a fee, or they're being charged a fee from the brokerage firm already. So they're disclosing that to the seller. Because in some states, the person working with the buyer pays the fee to the agent working with the buyer. And the person working with the seller pays the fee for the seller.
so you just need it for both parties.
So here, the seller's willing to pay the fee for both parties because the listing agency is sharing part of that with the other firm. Okay? Each buyer representation agreement, whether exclusive or non-exclusive, must contain all of the following provisions except A, the manner in which any fee or commission will be paid to the broker, B, appropriate signatures and dates, C, price and terms, D, conspicuous and definite beginning and expiration dates. Now look at this. If it's a buyer representation agreement,
So let's see.
do you know
What
the
house
price
we're
and terms you're going to buy for the house? Not yet. You can put down what you want or what you're looking for, but you don't know. Normally, you could say up to this price. You could say in this certain area, I would like an owner carry. You can say those type of things, but it's not going to have everything written down in there. I want to include the dog run. I want to include this or that. So C is the one that is not a must contain. It could contain certain price and terms. Each seller representation agreement, whether exclusive or non-exclusive, must contain all of the following information except A, conspicuous and definite beginning and expiration dates, so when it starts to be listed, when it ends. B, the commission split the broker has with the listing agent. C, price and terms. D, fees or commissions. We talked about this earlier. We might know the total brokerage fee, but you don't have to disclose how much is going to the other side. Okay? And this particular one's talking about the total fee coming into the brokerage firm, and my listing agent gets this. Oh, you're on a 70-30 split within the office. That's not required to be disclosed. It's the total fee that they're paying. Broker representation agreements with a buyer or seller may be electronically generated or transmitted, faxed, or delivered as long as A, copies of the agreement do not have signatures, B, the agreement specifically allows for such transmissions, C, the parties to the representation agreement agree orally, D, electronically generated agreements are not legal. The broker representation agreements with a buyer or seller may be electronically generated or transmitted, faxed, or delivered as long as the agreement specifically allows for it. So many of the contracts will talk about that and have a provision there that says electronic signatures permitted. State law permits it, but until the parties agree to do something like that, I might not want to accept an electronic signature. Our purchase and sale agreement, our listing agreements, the other things permit us to do so. Why would you not want to have an electronic signature?
Fraud?
Yeah, there's some fraud that can be out there. Because right now, if you have access to somebody's email, you could go in because they received the request and you can sign it. Or, oh, send it to this email address. Well, I send it to that email address. It verifies the email address, but how do you know that that's really the person? You may not. Okay? All right. We spent an hour, and I promised just an hour for everybody. So that's to the section right there for brokerage representation stuff. Done with that. Anybody have any questions? It has been.
Yeah.
You know, we could go a couple more hours, but I've got some other commitments. So I'm going to go ahead and stop the recording.